Let me offer a word of blessing first upon the food that you've already eaten. So let's pray together. Good God, we give you thanks for this day, for your countless blessings, for indeed we are blessed beyond our wildest imaginings. So we are a blessed people. We thank you for the blessing of this food, and we thank you for the blessing of this chance to gather here and learn about the tough decisions that all of us need to make. So be with us. May this be a productive and creative time, for we ask it in the name of Christ our Lord. Amen. This is our final event. Just a couple of words. If you have indeed completed the funeral memorial planning sheet, make sure that you share a copy of that with the church office. There will be a subsequent letter coming out from the deacons to the entire congregation with the hope that more of the congregation will complete the form and share it with the office so that we have it on file when we need to have it. And so be looking for that letter that will probably come, we hope, before God goes to the beach. Also a reminder, if you haven't purchased your copy and would like to have a copy of the Invisible Conversations with Your Aging Parents, they're $11 a copy, written by one of my colleagues, Shannon White. Very, very helpful resource. You've noticed that Steve has been taping our seminars. The deacons plan on putting all of the workshops together on one DVD with the hope that it will be a resource that will be available to the congregation. And the joke at the deacons meeting was, you know you're in trouble if Charles or Dale come to you with the DVD. But eventually that will be available as a resource for us. We are particularly pleased to have Jeff Goldstein with us this morning. Jeff has been practicing elder law for the last 15 years after a stint as corporate attorney with Simon & Schuster, and then an excursion into middle school teaching, and now for the past 15 years has been an elder attorney. So we're delighted, Jeff, that you're with us and looking forward to what you have to share with us. Thank you for coming.
Thank you. Good morning, almost afternoon. Thank you for having me here today. After what I heard Charles say, I do, notwithstanding the fact that he wants these forms that he's handed out to all of you to be filled out, I do wish you all long life. Hope they're not used soon. I look forward to addressing and to answering questions you may have about the law as it relates to financial planning. Okay, it's a huge area, and I'm going to let you help me decide what topics you may want me to cover, because some of them, my greatest expertise is in the Medicaid planning area. I understand somebody last week, okay, but you've had previous workshops, and to my knowledge, they've covered medical decisions, healthcare proxies, I assume, healthcare directives, living wills, and things like that. I understand that they've covered funeral planning, and that goes to the point that Charles was making. In connection with that, there is a document, it's a statutory document called the Disposition of Remains, where you can provide, and I have a copy here for anybody who's interested in seeing it afterwards, but you can specify who is in charge of handling your funeral preparations and matters. It's particularly important for example, single people. Generally, obviously, it would be a spouse if you had a spouse at the time. But it's very helpful. It gives some specific directions, not dissimilar to, I'm sure, what your document provides, but most places I speak at and most people I deal with don't have a document like that to begin with. So it's here if you're interested. Did anybody speak to you about prepaid funeral arrangements? Prepaid funeral arrangements? Okay. That's basically a Medicaid concept. And if it turns out that you want to get into a discussion about some of the specifics of Medicaid, the one thing you should know is that a prepaid funeral contract that is in accordance with the Medicaid provisions, which is really very simple. You go to your funeral home, you prepay for what you want. They check off that it's a prepaid Medicaid compliant arrangement. And that, whatever you put into that, they put it into escrow, the funeral home does. And that asset is exempt for Medicaid purposes. So for example, if you, sorry if I'm repeating what you may have heard, but you're only allowed, as of this year, $14,400 in non-exempt assets to qualify for Medicaid. But if you've got a $12,000 prepaid funeral arrangement already taken care of, that is an exempt asset, and that won't count towards the $14,400. So if somebody is in a Medicaid planning stage at any point, a prepaid funeral arrangement that's compliant with Medicaid is a very useful tool. Residence options, I believe they've spoken to, respite care, and of course home care, which really is a Medicaid topic and which I understand was covered in some detail at your last event. Was that last week or
3 weeks ago?
Okay. If there are any questions on any of these topics, I'm more than happy to try and answer them. They're all topics that I'm relatively familiar with. Yes, ma'am.
Long-term insurance, a good thing?
I'm pretty sure that I actually have on my list of things. Let me get to it, because I am going to get to it.
Yeah.
Okay, I'm absolutely going to get to it. The one thing I noticed on here that wasn't covered, and I call it the most important document that most people don't have, and it's a durable power of attorney. Okay? How many of you have durable powers of attorney in effect at the moment? Okay. Any idea how old they are? 5 years old, 8 years old, 20 years old? Okay. In 2009, there was a new statute passed by the state legislature, which differs substantially from the prior one. It's much more elaborate, it's much more complicated. The idea at the time was that they were all concerned about seniors being taken advantage of. They tried to put in all these protections for seniors. And so they turned what was a 4-page document into, frankly, what for most elder law attorneys who add provisions that are elder law specific, if you will. It's now turned into a 14-page document, unfortunately. But one of the key provisions in the power of attorney, if you're doing Medicaid planning, is what's called the gifting provision. And the durable power of attorney comes in 2 parts. There's the first part, which is your basic one, but it doesn't have any gifting provisions. And the second part is called the master gifts rider. Okay. And if you're doing Medicaid planning of any kind, having your agent have the ability to do gifting is key to the whole process of planning. Okay, so that if you have a durable power of attorney that doesn't include gifting powers, extensive gifting powers, pretty much unlimited gifting powers, then you may not have a power of attorney that's adequate for Medicaid planning should you in fact ever need it. Okay? But let's talk about what a power of attorney is. It's a document that appoints one or more individuals to act on your behalf for non-health matters. Okay? Healthcare proxy covers health. People ask me, well, why don't you enumerate for me what it is that the durable power of attorney would cover? And the way I do that is by saying absolutely everything and anything you can possibly think of that doesn't have to do with health. That's what the durable power of attorney does. It gives your agent the ability to handle every other aspect of your life, essentially. It comes into, it serves its purpose if it's just inconvenient for you to act on your own. Let's say you've had hip surgery and you're sort of out of commission for a while and you can't get around and whatever. And you don't have a joint bank account with somebody. It gives you the ability to have your agent who you trust, often your child, often not your child, handle your affairs on a temporary basis. More often it comes into play when you're unable to handle your own affairs on your own, not because you're incompetent, that's the next step, but rather just because you may be bedridden, house-ridden, you just can't get around. You can't get to the bank. You can't do some of the things that go to the post office, whatever it may be. You can't do the things that are necessary to handle your day-to-day living things. And that's what the agent under a durable power of attorney would be able to do for you. The last point that's on the bottom of the slide is what makes it so important and what the word durable has to do with it. It's not durable because you can't rip it up. It's durable because even if you become incompetent and no longer have capacity, mental capacity, the power of attorney continues in effect, which is incredibly important because if you didn't have that, you'd have to go into court and there'd have to be a guardianship proceeding initiated, which is a costly process, and somebody would be appointed your guardian. Often those are contested. Sometimes they're contested between children. Sometimes they're contested between other relatives. And sometimes if nobody's interested, you end up with a court-appointed guardian. But any way you slice it, it's an expensive, time-consuming, unpleasant experience. Even if you're incompetent and don't know what's going on, it's very expensive, it's time-consuming, it's just a process that can be avoided, and it can be avoided with a simple piece of paper, the durable power of attorney. And as I talked about before, now we're getting into this protecting your financial assets. It gives your trusted agent, and whoever you select as an agent needs to be somebody you trust, the ability to undertake emergency asset planning when you're unable to do so yourself. I mean, that's basically Medicaid planning. I mean, that's what I'm talking about when I refer to that. There is a handout here that talks about some of the highlights of the durable power of attorney. I don't want to get into how it's set up or all the different ins and outs of the document. What I've told you is enough to give you a sense of what it does and why it's there. I do consider it, as I said, the most important document that most people don't have. You should be aware that the document, one of the hesitations that people have about dealing with the durable power of attorney, is that it does take effect immediately. Unlike a healthcare proxy, which only takes effect when you're not able to convey your own decisions. The durable power of attorney takes effect when it's executed, and signed by the agent. There are a couple of ways around that. The way I recommend to many of my clients who are uncomfortable, let's say they've chosen their children, but is you can have it executed and just don't give it to them yet. You know, they can know where it is, they can have access to it if it's needed, but you don't have to give it to them. And sometimes that makes people feel better. I always, I'm torn in those situations because if you don't feel comfortable enough to give it to them when you execute it, then I'm not sure you're going to feel so comfortable about it when they're actually able to use it. But that's one alternative. The other, of course, is to leave it with the attorney. That's a tougher one. I try not to do that because I don't want to be in the position of having to make the decision as to when it is that my client might want that document actually handed out. There are too many different possibilities. But I would suggest to you that not having a durable power of attorney in effect just because you don't necessarily want your agent to have those powers or the ability to use those powers immediately is not necessarily a good reason for not having it, because you could be hit, we all know. You can be hit by a truck, you can be running a marathon, anything can happen. And then all of a sudden you don't have this document available in place, and there's nobody around who can act on your behalf without a guardianship proceeding. So I consider it a very important document. Another document that I should just mention is there's something called a designation of a standby guardian. It's used mostly for minor children. I'm not sure that too many in the audience have minor children, but you probably have minor grandchildren. Hard as it may be for you to give advice to your children these days, which they don't want to hear from any of us, it's actually relatively important to have a document which provides for who it is that's going to take care of the grandchildren in the event something should happen to the parents. It's certainly important in a situation where you have a single parent household. It's another document that's available for you here to look at, just to have, take with you. I'm not going to spend any time on it, but it's something that probably hasn't been covered, and I thought I'd mention because it just falls within the ambit of sort of legal protections for the family, which is what I'm trying to address. So with that in mind, there are a whole slew of topics that I can cover. On the estate planning side, I can talk to you about probate and non-probate assets and what they are and what the difference is. The topic could be wills versus revocable trusts. There are a lot of people out there who have been sold on the premise that revocable trust, that these wonderful organizations, they provide you great lunches and whatever, and by the time you walk out of there, they've convinced you that everybody should have a revocable trust, and shell out however many dollars they want to give you this revocable trust. There are circumstances where a revocable trust is a good idea. I certainly don't think it's necessary for everyone. And again, I can sort of get into the ins and outs of that if you like. IRA and pension beneficiary designations, the importance of having one so that your retirement fund doesn't end up in your estate. It can pass out, go directly to your beneficiaries if you have named beneficiaries. If you want it outside of your estate, if there's no named beneficiary, it goes into your estate and has to be distributed within 5 years. If there's a beneficiary named, those beneficiaries get a long period of time in which to take out the funds, the principal that's in that IRA, and so there's a tremendous financial planning advantage to having named beneficiaries. I mentioned the disposition of remains. I can talk about the treatment of life insurance. Lifetime asset protection. I can talk about irrevocable trusts. Since the topic's been raised, I will address it right now. Long-term care insurance and what's known as the New York Partnership Plan. So if I understood your question, I think it was as simple as, is it a good idea? Okay. Everybody familiar in principle with what long-term care insurance is and does? There are so many variables nowadays, variations on long-term care policies. When they first came out, they were real simple. They would provide you with a certain amount of dollars. Once you qualified under the policy, it would cover a certain amount depending upon how much you wanted and how much of a premium you were willing to pay. And that would cover either home care or institutional care. Now there are combinations that combine it with life insurance, where some of it you can pay it in, and then if you don't use it, you get it back. There are a million different types of policies out there. I'm not going to address all of them. What I will address is whether having long-term care insurance makes sense. It depends on your particular circumstances. I mean, the premiums for long-term care insurance have gotten very high, okay? If you're in the 50-55-year-old range, then the premiums are relatively reasonable. Although they used to be the same for men and women, they're now raising the premiums higher for women than for men because women are living longer. They've decided to make that distinction. Another problem with the long-term care insurance is, although they promise you that your personal premium rate will not go up as opposed to everybody else, they have the right, with the approval of the state insurance board, to raise premiums across the board for everybody in your group, if you will, with your type of policy. And they've been doing that. In fact, almost every long-term care policy issuer has raised their premiums. So you're paying this premium for you buy it at 55, you're paying whatever the premium is every single year, okay? Unless and until you're ready to use it. And you can't use it until you are, there are things called ADLs, has that been discussed with you? The activities of daily living, toileting, bathing, dressing, etc. Most policies require you to at least need 3 out of 5 of those ADLs in order to be eligible under a long-term care policy. Then there's a period called, there's an exclusion period, usually about 100 days. And then it provides you, with some coverage, okay? Rarely is it enough to cover everything because with the rising costs of health care, and you just can't buy enough. Although I do suggest that if you in fact buy a policy, that you make sure it has a pretty standard 5% inflation rider on it, so that the amount you buy goes up 5%. The amount you're entitled to goes up 5% every year during the life of the policy. For quite some time now, there's been something called the New York Partnership Plan, and it's a type of long-term care policy. There are only a couple of states in the country that have this type of plan. And what it does is it says, okay, if you buy 3 years worth of long-term care coverage, now I think it's up to 4. When I bought it, it was 3. But it's probably up to 4 now. And you use it, and you then need to apply for Medicaid, you can do so, and you do not have to reduce your assets down to $14,400. You can have any amount of assets whatsoever and be entitled to qualify for Medicaid in New York if you have had a New York partnership policy. Now, it doesn't cover income. In other words, if you have substantial income, since on the income side, well, if you're in a nursing home, you're not allowed more than $50, and the rest of it goes towards what's called the NAMI, if that was discussed. Gets contributed before Medicaid kicks in. But that's not very hard to deal with, because what you simply do is you take your resources, your assets, and you convert them into non-income producing assets. So that Medicaid isn't taking your income from you at the time that you may choose to use it. The other potential drawback to the partnership policy is that, well, initially you had to use it in New York. Okay? So let's say you'd gotten older, you would move somewhere out of New York, you needed to qualify, you'd have to come back to New York in order to use that policy. There are several other states that have adopted a reciprocity because they have similar types of policies. There are about 4 of them at the moment. I think there will be more as time goes by. So that's, that's a drawback, but if you need that kind of care, the one thing that it does provide for is, unlike the limitations that are otherwise put on your resources, if you have a New York long-term policy and you use it anywhere in the country, the amount of money you paid in to that policy, you'll be able to retain that amount in assets. So whatever you paid in over your lifetime on that policy will go towards, be able to retain that amount. Is that clear?
Yeah. So, let me see if I get this.
Okay.
For the New York partnership, you pay for 4 years. Is that right?
Well, no.
Okay.
You pay for your lifetime.
Okay.
You pay every year.
Okay.
It buys you coverage. What you're buying is coverage for 4 years when you first become eligible for it or need it. Okay? And once you've used it for those 4 years, you then can go on to Medicaid regardless of what your resources are. You can have $1 million in resources, and if you've had a New York partnership policy and you've used it for the required 4 years, you can keep your $1 million. Okay? Is that helpful?
Mm-hmm.
The second part of it is a little more confusing, where I was talking about using it out of state, and I don't want to, I don't want to spend too much time on that.
So how does that compare with long-term care?
Is the partnership policy a little more expensive? Yes, but not appreciably. And the earlier you buy it, the less the less of a difference there is. I mean, when I did it, there was just no question in my mind that it made sense to have a long-term care policy.
But you're saying a private one might be cheaper?
Well, the New York, it's all sold by insurance companies. I mean, you don't get it from the state of New York. It's just a particular, it has to have particular requirements that are in the New York partnership policy and qualify as that. If you buy a non-New York partnership policy, yes, it is likely to be less expensive, but I don't know how much less expensive nowadays. Yes, ma'am.
If you already have long-term care, can you also get the state partnership plan?
No, I mean, if you already have a long-term care policy that is not a New York State partnership policy, you'd have to stop on your.
Oh, so you'd have to stop.
You can't convert it. It's not the kind of thing that can convert it. Could you buy a new one?
That's what I mean. Can you do both at the same time?
Can you buy a new one?
Only to protect.
I don't know the answer to that. I'm sorry.
Like to
I
protect
honestly
your
don't.
assets.
But if you were to try and buy a new one, you'd have to buy it at your current age, which is
correct. Correct.
Presumably, if you have one of these policies, as I do, that's
Right.
before the long-term care, the New York State Partnership
Yeah.
existed,
Right.
you're paying premiums based on how old you were when you bought it
Correct.
15 years ago.
Correct.
And so,
Yes.
Right. So you
But
pay your old premium on the policy
I
you have, and then you pay a
extra.
new premium based on the new policy you're buying.
So I could have two.
I'm going to say yes. I can't think of any reason why you couldn't have two, but
Only
it would be
because
costly.
the New York State allows you to keep your assets, so that's a big,
Right.
that's big.
You'd really have to check with someone who sells that stuff.
Okay,
I
thank
don't,
you.
I don't sell
Yeah.
long-term care
But all the money,
policies.
if you're talking about,
Plus you get it back.
that's the point is, if you are talking about stopping your old one and starting a new one,
Yeah.
all the money you put in the old one is gone.
Oh, yeah, no, I wouldn't
Right,
stop,
so
I would not
you would not-
stop.
She would continue both
Yeah, I would
policies. That's
continue.
what she.
I would continue both policies, and
Right.
what you said you would get your New York State money back.
Well, no, you don't get
You
get.
said what you put in, you would get back?
No, what I said with respect to out of state,
Yeah,
if the
no,
state
no.
doesn't have reciprocity,
Oh, right.
okay,
Mhm.
then let's say that over the course of the years you've been paying premiums, you've paid $130,000 worth of premiums, then the resource amount that you'd be allowed to retain in order to qualify for Medicaid anywhere in the country would be the amount you paid in premiums, the $160,000 instead of the $14,400.
Okay.
Okay.
Thank you.
Disability insurance, Medicaid planning. I do have a handout that's over here that goes into all the ins and outs of Medicaid. Home care Medicaid, institutional Medicaid, if you're single, if you're married, if you're, I said institutional or home care. So it covers all of, and the penalty period and how the penalty period is calculated, etc. It's all there. I have a separate PowerPoint, which if you wanted me to, once we decide what it is we want to focus on today, I can go through it with you. But the handout can also cover that for you if you just take it with you. There's some interesting Medicare parts that go into the Medicaid. Did they talk about Medicare at all and how it impacts on Medicaid? Okay, the 100 days and all of that, that's been covered. Okay. Somebody stepped on my toes. Providing for children and grandchildren. Lifetime inter vivos trusts that you can set up, 529 education accounts that I'm sure most of you have heard of. Be careful on the 529 education accounts if you're in a Medicaid situation, because those are considered available assets, because you always have the right to take the money back. Since you can take the money back, you can put 100, 200, whatever it may be into a 529 and you want to qualify for Medicaid, those 529 accounts, to the extent they haven't been used, are an available asset.
Wow.
Okay? So just be aware of it. It doesn't mean that setting up 529 accounts aren't a good thing. It depends what your goal is, which is the same, which is true about all of this planning. What's your goal? What are you trying to accomplish? Annual gifting. This year it's $14,000 to anybody you want, not just relatives, anybody you want. If you have enough money, you can give $14,000 to the entire town of Mount Kisco. Again, when it comes to Medicaid, people don't understand that the Medicaid rules and the tax laws have nothing to do with one another. Even though the tax laws say you can give $14,000 away without a tax consequence, as far as Medicaid is concerned, if you're going in for institutional Medicaid where there's a penalty period imposed, that $14,000 will be counted as a penalty. Because they don't care that, about the tax law, they just care that you gave away money. And they don't want you to do that, not within the 5-year look-back period anyway. Gifts to minor acts.
Can you explain that a little bit, the 5-year look back?
The 5-year look-back?
Yeah, what does that mean?
I'm sorry?
Piles of paper.
Yeah, okay. Let me see if I can do this without putting up the whole PowerPoint, and then we'll decide whether we need the PowerPoint anyway. Let me just hold off on that, because I'm just going to, the gift to minor accounts, be careful with them, because once you put something in a custodial or a gift to minor account, once that minor becomes 18 or 21, depending upon the age, it's theirs. It's their money. A lot of people don't realize that. They think that somehow or other they're going to have control over it, as if it were a trust or as if it was a custodialship. Yeah, it's custodial until they become of age. So it's, if you really want to put significant amounts of money in the name of children, grandchildren, etc. Children in this case, they'd already be of age, but grandchildren, you're much better off doing it in sort of a trust, in a legal trust document where somebody other than they controls it for as long as you want them to control it, or into a 529 where the individual child has no control over it, you have control over it, which is why it's included in your Medicaid.
But that money is still put in the laundry list of Medicare, Medicaid? At a time period?
Yeah, it still would fall within that 5-year look-back period if you did it within the 5-year look-back period. Okay. The last one is providing for disabled family members. How many of you are familiar at all with what a supplemental needs trust is? Okay. A supplemental needs trust is a trust that can be set up. There's a lot of technicalities, but think of it as a trust that can be set up for someone who is otherwise receiving governmental benefits of some kind because of their disability. And you can set up a trust for them that will provide extras for those individuals, supplement what they're getting from the government without disqualifying them from government benefits. So if you have somebody in your family who is disabled and you have an interest in providing for them, there is a vehicle to do that. And again, a lot of people aren't aware of that. And it's something you would do. You can do it in a will. You can do it during your lifetime. As an elder law attorney, I will not draft a will that does not have what I'll call a trigger supplemental needs trust in it. Because you're writing your will today. You haven't a clue what's going to happen in the next 10 years. Okay? And let's assume, God forbid, one of your beneficiaries under your will has a disability and is collecting government benefits at the time you die. And all of a sudden they inherit whatever it may be, 50,000, 100,000, more. Well, that, unless it goes into a supplemental needs trust by the terms of your will, because your will, as it's been drafted, says, if any beneficiary is receiving governmental benefits, it shall not go outright to the MAPRIGHT, but rather shall go into a supplemental needs trust. Then all of a sudden, all that money can be used for the benefit of the disabled individual without taking them off of governmental benefits. And you can also provide that when that individual passes, any money that's left in the trust goes elsewhere to your well beneficiaries. Okay? Understood? Mm-hmm. Just something to think about, and to think about in terms of your wills if you choose to. As I say, many lawyers who don't practice in this area are not familiar with that and don't include those kinds of provisions in their wills. Okay, so those are all the topics I can discuss.
I'm sorry,
yeah.
Before you go on.
Sure.
I know that my parents in their will have my brother, who is disabled, he's a, I forget how it's done, I think he's a beneficiary, but it's under a trust.
Right, a supplemental needs trust.
I'm not sure.
I'm sure it is.
Okay.
If your parents drew their wills knowing they had a disabled child,
Right.
then my guess is that it was drawn
Under
with
supplemental.
a supplemental needs
Okay.
trust in it.
But
Most
that's the
people,
question that she needs to ask of her
Yep,
parents.
I have to make sure
Right.
that it's something.
right, that it
has to be
meets the
supplemental.
that it meets the definition of a supplemental needs trust. And
Okay.
I would be almost positive it is. The key that I'm addressing is the situation where when you draft your will, you don't have anybody disabled. Okay?
Right.
And subsequently they become disabled, and you don't go back to your will. You know, people don't revisit their wills that often, and they don't nor do they understand that. Okay, well, I left 50,000. I left it 50-50 to my two children. One of the children is disabled. Won't it be great? He'll have all this money that he or she can now use to assist them in their, in their disabled state. What they don't understand is what they've done is they've essentially taken that individual off of all the government benefits that are being provided. Did you have something, John?
I was going to ask in terms of the question, what's most important in a will, from your point of view? What are some of the things we want to make certain that are in our wills? And then what might be some of the biggest mistakes that we make, from your experience?
Good question.
Okay. Start. What are things that should be in it? What are
the most important things when I'm coming to
Right.
you as a client?
Okay.
I don't have a will.
Right.
What do we need to draw up?
Well, the first thing I'm going to do is ask, for a family tree. I'm going to want to know who's in your family. I'm going to want to know if any of them are disabled. We're going to talk about the level of your, what your resources are. Do you expect that you'll have more resources? I mean, your parents still alive? Do you expect an inheritance at some point? What do you want? Where do you want your money to go? Just based, and because remember, a will only takes effect when you're dead. You can be amazed the number of people that don't quite get that. All right? So it has nothing to do with planning for your retirement.
Right.
It has everything to do with planning for where you want your assets to go. But it involves, to a certain extent, guessing, if you will, what those assets may be. I would say the absolute most common mistake that people make, and this goes to probate and non-probate assets, is that the only thing that passes under your will is that which passes through probate. Begs the question, what doesn't pass through probate? Okay? There's a laundry list, any joint account or survivor account, anything with a named beneficiary, your IRA, life insurance. I mean, there are a myriad of things that do not pass through your probate estate. And it's really important for the attorney to gather all the information as to how your assets are held and who, if anyone, is named a beneficiary under those assets. Because I've seen remarkable number of situations where intentionally or unintentionally only one child has been named the beneficiary of a particular account. And yet the will provides for 50-50. Keep it simple, two children, 50-50. But if money has gone out and is going to one child or another child through a different vehicle, okay, then the ultimate division of your assets is not going to be 50-50. And somebody is going to be real upset. That's probably the most common in terms of that. I could talk about, tax issues. Obviously, at the moment, we have fairly liberal estate tax levels, 5.2 million, I believe it is, or 5.3 as your estate tax level. I don't know. Frankly, I don't have many clients that are in that level. But you do have New York state tax, the state tax, or death tax as it's called, that kicks in at $1 million. Something to think about. Sorry?
So in terms of this probate, non-probate thing, the distinction you seem to make is that if you have assets and they have beneficiaries stated, then they're going to be non-probatable.
They're going to pass outside of probate.
Outside of
Right.
probate. Okay?
Correct.
And the other distinction you're making is that when you set up beneficiaries for non-probated assets, you want to do it kind of the same way you got in your will, so they're consistent.
Well,
with
that's
each other.
correct. The problem, what ends up happening though, is let's say one kid is in California and the other one's here in New York, so you set up these joint accounts with the one that's in New York, thinking that, because for the convenience of it, and they have access to all of that stuff if you need them to, and all of a sudden, and then you have your problems. Another thing to be aware of is that if you have out-of-state property, okay, out-of-state property cannot be probated in New York State, okay? You have to have what's called, because probate can only take place with respect to the situs of the property. And with real property, it is where it is. With all the rest of your property, it sort of is up in the air. But real property is where it is. So if you have a home in Florida, for example, in addition to your home in New York, it may make sense to try to take that piece of property and get it out of your probate estate. Why? Because you have to conduct an ancillary probate proceeding down in Florida. And that could be a pain in the neck. Okay? How do you do that? You do that by setting up a revocable trust. And a revocable trust is a trust that for all practical purposes is you. Your Social Security number, not a new Social Security, not a new employer tax ID number. Everything in it is taxed to you. I mean, everything about it is you, except it's in a trust. But the fact that it's in a trust means that it's not going to pass through your probate estate, and you can provide for that Florida house to go to your children in equal shares, for example, at your death, and it will do so without having to go to court in Florida to accomplish that. Okay? So that's when I said there are reasons for having revocable trusts and reasons not for having revocable trusts, that's a very good reason to have a revocable trust. I now have a client who has property in Jamaica and the Bahamas, and I'm trying, and they're quite elderly, and I'm trying desperately to get those properties into a revocable trust so that we don't have to go through the machinations of a legal proceeding down there when they pass away.
Can you have multiple revocable trusts?
You can.
Okay.
You can, but there's no necessary. I mean, it depends on what. Let's say you had a Vermont house, ski house, and a winter house.
Yeah.
Okay. You could put both of those into the same trust.
Okay.
You don't necessarily need two trusts to do
There
it.
was a reason to.
But if there was a reason, you could have as many trusts as you like.
Okay, revocable and irrevocable. Not irrevocable. Irrevocable is only one, right?
No, you can have a bunch of irrevocable trusts.
You can. Okay.
The obvious difference between the two is that one is irrevocable. Most of those are done for For non-Medicaid people, those are done primarily for tax reasons, to take them out of your estate, the irrevocable trust. For somebody who's thinking in terms of Medicaid eventually, this sort of pulls us right into the look-back period, okay? Under Medicaid rules, at the moment, I don't think it's going to stay this way forever. We managed to thwart it off again this year. Right now, there's a distinction between home care Medicaid and institutional Medicaid, or nursing home Medicaid. In the case of home care Medicaid, that is to say, you have somebody coming to the house for a given number of hours, providing a given number of assistance. There's no penalty imposed whatsoever for giving your assets away. So you could have $1 million today, get rid of it by the end of the month, and I could qualify you for home care Medicaid on May 1. There is no penalty for giving your assets away to be eligible for home care Medicaid. Simple as that. Problem is that if at some point you need institutional Medicaid, you need to go to a nursing home, you can't live at home anymore, then all of a sudden you're looking at this 5-year look-back period. And what it is that if you need a nursing home, from the date you're looking to become eligible, okay, and to become eligible for a nursing home, you have to have less than $14,400 in assets. Okay, so first you have to accomplish that. But once you've done that, they are then going to look back 5 years to see whether you've made any gifts. And if you have made any gifts during that 5-year period, I'm going to use round numbers to make it easy. For every $10,000 you've given away during that 5-year period, you will be ineligible for Medicaid for 1 month. Given $100,000 away, you're ineligible for 10 months. Okay? How did I'm trying to remember how. Oh, the irrevocable trust. So, if you've set up an irrevocable trust for tax purposes, I mean, it's sort of most people won't be setting up an irrevocable trust for tax purposes if they have Medicaid in mind. That you just, usually you have more money than that, you're not going to end up being a Medicaid person. But if you know, for example, that Medicaid may be somewhere down the road, and your hope and expectation is that you can live at home with home care Medicaid and get through a 5-year look-back period, then you can set up what's called an income-only irrevocable trust, IIOT, irrevocable income-only trust. Okay? And what that does is you take your assets, you put them into this irrevocable income-only trust. You are entitled to the income from that trust. You are not entitled to the principal. It's one of the things that most people find most objectionable about it, because they are giving away control of their assets to somebody else, usually the kids. But if 5 years passes between the time you've set up that irrevocable trust and the time you need nursing home care, they won't see the trust. Whatever you put into that trust, the $500,000, whatever you may have put into that trust, will not be subject to a penalty.
But that's because it was more than 5 years ago.
Right, because you set it up more than 5 years ago.
So
but
it doesn't matter how you did it, it was more than 5 years ago.
Correct.
So I think the point you're trying to make is that it's less than 5 years have elapsed. What happens then if it's irrevocable?
Okay, so if you've set up this irrevocable trust and you end up needing a nursing home, there are ways to unwind the trust. Basically what I say to my clients when you do this, if your trustees are the kids, you know, the kids have to understand that they can't go into the principal of that trust during its existence in your lifetime, because there may come a time when they have to give that money back. If you go into a nursing home within that 5-year period and the money has to be returned in order to eliminate the penalty period, then you have to engage in a different type of planning. You're not going to save 100% of your assets, but at the moment, there's still a method on a shorter term basis to protect some of your assets. Let me just try and cover that. It's called a gift and promissory note. That's the way it's done. The specifics of it are unimportant right now, but the idea is that if you have $200,000 worth of assets and you need institutional Medicaid, you give away $100,000, you incur a 10-month penalty period, you keep $100,000, the $100,000 you keep pays for the penalty period, you've still accomplished getting $100,000 out of your estate. I mean, the numbers don't work that perfectly, but that's the concept. That's the concept. Yeah.
Husband and wife, still alive, one goes to the nursing home.
Right.
Impact, where does that come with the 5-year look back?
I'm doing pretty well on time here. So before we get to that, 'cause I think I do want to get to my Medicaid slide. I think it sounds as though, although it's been covered, it hasn't been covered as adequately as I think it should be. But before we do that, are there any other parts of, you know, what I've said I can talk about on your beneficiary designations? Every once in a while, well, first of all, check your file. Make sure you have a copy of a confirmation of who your beneficiaries are on your IRAs. Not enough, in my opinion, to have just told the bank or filled out the form at the bank. Okay? You should have a copy of that, because trust me, they lose them all the time. All the time.
The beneficiary or the bank?
The bank loses it. Unbelievable. Unbelievable how many times clients have said to me, well, my kids were the benefit. When I filled out the forms, I said 50-50 to the kids. And the bank can't find the form.
Well, especially, you know,
with all the
today.
mergers,
Yeah.
bank mergers and
Yeah,
stuff. I mean, this
absolutely.
stuff is disappearing all over the place. So please, make sure you have it. If you don't have it, contact your bank, your retirement holder. If it's a 401k and it's a plan holder, your plan holder. Tell them to please send you new debt beneficiary designation forms. Fill those forms out. Send them back in. If they're duplicative of what's already there, so what? But at least you now have a copy of exactly what it is, and you know that you have it, and if they say they've lost it, you can pull it up. Incredibly important. On the revocable trust issue, so there are what's called these revocable trust mills. I mean, unfortunately, some of my colleagues make a great deal of money setting up revocable trusts. What they do is they try and convince you that going through probate is an onerous thing. They're going to try and convince you that the cost of going through probate is exorbitant. The fact of the matter is that I think that the biggest fee that the court itself can charge, no matter what your state is somewhere in the neighborhood of like $1,800 for the filing fee. Now, yes, do you need a lawyer? Of course you need a lawyer. Is it going to take forever? No, you're going to get your letters testamentary or, and then you'll go through the process and you'll have, to some degree, court protection. over how the estate is handled. What these other individuals will try to convince you is that because the probate proceeding is so terrible, you should set up these revocable trusts. Get everything out of, everything you own should be put into the revocable trust. All of your bank accounts should be in a revocable trust. Your house should be in a revocable trust. Virtually everything you own should be in a revocable trust. That way, when you die, it's all controlled by the trust and doesn't have to go through probate. The problem is that means you actually have to transfer all those assets into the trust. And most of these organizations, mills, whatever you want to call them, they don't help you do that. They just set up the trust. And then they say, just make sure that you get everything into the trust. Most people haven't a clue how to do that. You have to so your bank accounts are going to be retitled. The Jeffrey Goldstein checking account under the Jeffrey Goldstein revocable trust. Everything you do is going to say revocable trust. Your house is going to end up in the Jeffrey Goldstein revocable trust. You're going to have to go to your local tax people to make sure you still, the star exemption is properly handled and this, that, and the other thing so that you still get all the benefits, but everything is now handled in a trust. And most people, 99% of the people who set up these revocable trusts don't get everything into the revocable trust, and even if they miss 10%, only 10%, they're still going to have to go through a probate proceeding for the other 10%. You're still going to have to go into court for the 10% anyway. So, to me, to avoid probate in a state like New York, there are other states that are different. But New York's probate process is not that onerous. And to go through the machinations, if you will, of setting up revocable trusts for all of your assets simply to avoid probate just doesn't make sense to me. It just doesn't. Yeah?
Quick question, right?
Yeah.
Regarding wills.
Yeah.
Can elder law lawyers, in any case, act as executor of wills?
They can. There's a certain document that has to be signed where you make a knowing, knowledgeable waiver of the conflict, because there is a conflict.
There's a fee, of course, for this. There's a fee.
Yeah. Yeah, they're going to charge you
5-10%.
Well, make a distinction between an executor is entitled to a statutory fee under New York State law. Okay, if the lawyer executor is also the lawyer for the estate, the lawyer will get his statutory fee, whatever it may be, for handling the estate, and then he or she will also charge you their legal fees for the actual handling of the estate. You're not going to get a 2-for-1 deal out of that. Did that answer your question?
Yes.
Okay. I hate when I lose track of where I was.
Did you have another thought? Or
I'm sorry?
Did you have another thought you wanted to say?
No, I just forgot where I was before the question was asked. We were talking about probate and non-probate.
I'm a little confused about what the difference is between revocable and non-irrevocable trust is. What is the basic fundamental difference? Why would I want to consider one versus the other?
Okay.
You talked about one having to do with Medicaid, but supposing that Medicaid is not
an issue?
Not
well,
an issue.
if it's a revocable trust is treated as your own as part of your estate. So for tax purposes, it's as if it didn't exist. Okay? So if your goal is to somehow or other lessen your tax burden, okay, and you want to set up an irrevocable, it needs to be an irrevocable trust where you give up complete control of the trust. In a revocable trust, you are the trustee of the revocable trust. So you can do whatever you want. You can amend it. You can pretty much do anything you want with it. It's, as I said, it's like you became it, or it became you. Okay? Does that help?
Yeah.
Okay. It only runs into trouble when you get into this Medicaid business. Talked about all that. that. Okay. Where's my good friend who's going to help me get the other PowerPoint up? Thanks.
Just go to the screen here. One to the other one.
I'm sorry?
So then-
Yeah, right. Medicare, Medicaid.
Yeah.
Thank you. Yes, because I want to tell you, I couldn't have done it. I've only recently learned how to do these PowerPoints. I have to tell you, they're wonderful, but you know, God bless our kids. If it weren't for my daughter, I never would have figured this all out. You know, if you work for a firm, you know, there's usually a technical, you know, you have an IT person or somebody who can show you this stuff. When you work alone, you don't. Okay, so I'm going to run through Medicare really quick, just parts of Medicare, because it impacts on Medicaid. All right? And I'm not going to spend an awful lot of time on it. But there are essentially 4 parts to Medicaid, Medicare rather. Forgive me, making the mistake that all my clients do. You know, there's a hospitalization, everybody knows about it. There's no premium, that's what you paid for all your life. There's a deductible and a copay after 60 days. Part B is your doctor's coverage. It's now costing $104.90 a month, plus a surcharge if your income's over $85,000. If there's an alternative to those, which is the Medicare Advantage programs, which cover A and B. The cost varies. It's just like that. It's an HMO. You get more, you pay less, but you're limited as to who you can go to. You know, who your doctors are, who your hospitals are. You're all familiar with that. Part D is the drug coverage. Most people don't understand the Part D. It's not relevant to most people unless you're taking serious medications, but everybody who is 65 or over has to have a Part D program. If you don't have one, you've been assigned one. If you're under straight Medicare. Again, there's at a different time, a different place, I could spend an hour and a half explaining Part D. Actually, it's one of the things that the Medicare website, Medicare has done really well, because all you do is you go to the Medicare website, you plug in all of your drug, you know, everything you take, how often you take it, in what quantities, milligrams, etc. And then they pop up with, you know, you do all that, you push a button, and it pops up with like 20 different plans you can join on your Part D plan, from the least expensive to the most expensive. Problem is, you know, what's that wonderful expression? The devil is in the details, because, you know, on the face of it, it looks like, oh, buy the least expensive plan, obviously, but you know, then the details get in, and you discover that they do this, they do that, and you can get messed up. It's also a problem if you change medications. You know, a medication gets added. What was under one company's plan when you didn't have that drug made this plan the best, but now that you have this drug, they charge more for it, so it gets, you know, not fun. But there's also rehabilitative coverage, and that's what we're going to talk about now. Okay, this is the kind of coverage that you get. Let's say you've gone in, could use I'll use a hip replacement for an older person. Okay, so let's say an older person has received a hip replacement, and they then need rehabilitative care in order to enable them to get back to the way they were and walk well. It's not a long-term care thing. It's not like a nursing home, although most nursing homes have rehabilitative areas. In order to qualify for rehabilitative care, you have to have had a 3-day hospital stay. Okay, you had a 2-day hospital stay, you're not going to get covered by Medicare. This has gotten really, really nasty recently because hospitals have been categorizing people as being there for observation. Okay? It's a huge controversy that's going on, and it's going to be litigated because they don't tell you. It all has to do with readmissions and how a hospital gets treated if there are readmissions. If they've admitted you and then you get readmitted, it hurts them. If they haven't admitted you and they're just under observation, then it doesn't hurt. But it hurts you because if you're under observation for any reason, if that's all they've categorized you. You know, let's say, for example, you go into that hip replacement. Okay, for the first 2 days they consider you admitted, and then 3rd day they categorize you as observed, and then you go out, you know, and looking for care for rehabilitative care at a nursing home or Burke or wherever it may be. Medicare is going to say, well, you didn't meet the qualification. You weren't there for 3 days. It's crazy. Unfortunately, lawyers like myself don't usually get involved early enough to, you need a family member or an advocate to actually ask these questions. We haven't figured out what kind of way there is to fight the decision, as to, to recategorize it, because it's only happened in the last 3 months, 6 months that they started to play this little game. But it's something you should be aware of. The maximum coverage for this Medicare rehabilitation is 100 days during a spell of illness. Okay, so let's assume you're covered. What do you get? The first 20 days of rehabilitative care are covered in full. Days 21 to 100, you pay $148 copay, which is often covered by your Medigap policy, if you have one, or the equivalent of it. But the coverage only applies while skilled care is required. Skilled care. Okay? So, if after 35 days, you're able, let's say it was a stroke instead of a hip replacement, or a heart attack, or anything like that. If after 35 days you no longer need skilled care, but what you need is custodial care, somebody to help you with the ADLs, toileting, feeding, dressing, moving, transporting from bed to place, then that's not skilled care, that's custodial care. That's health aid care, not covered by Medicare. Medicare had taken the position recently, in the last several years, that unless you were improving, unless you could demonstrate that ongoing skilled care would result in improvement of your condition, that you no longer were eligible for coverage under Medicare. Okay? The argument was made, well, what happens if without that skilled care you're going to deteriorate? Maybe you won't improve any better. Maybe you've reached your plateau, but without the care, that ongoing care, speech therapy, call it what you will, you'll deteriorate. We just had a case in the Federal District Court of Vermont where they decided that if the skilled care is needed to maintain a particular level, that it will be treated as necessary under Medicare, and you can get your maximum, your 100 days. It was a very important decision. It's helped a lot of us and a lot of our clients. So that's the Medicare aspect of this, which I just wanted to cover, because that's what then, it's when the Medicare runs out that the Medicaid becomes the issue. Any questions about the Medicare part of this? All right. Bare bones Medicaid. Non-exempt resources, $14,400. What are examples of exempt resources? Your primary residence up to $802,000 net of the mortgage. If it's worth more than that, they're going to consider the excess an asset. Your retirement account, if it's in payout status. What that basically means is if you're over 70, for most of my clients, if you're over 70 and a half, you're taking your RMD, your required minimum distribution. You have to take it in equal installments, so you have to do a little work to make sure that you're not taking excess, excess distributions, etc. But that you can protect your retirement account, no matter how big it is. I mentioned the prepaid funeral trust at the very beginning of my presentation earlier. Those are exempt assets. Term life insurance policies are exempt. Okay, you can have a $100,000 term life insurance policy naming your children as co-beneficiaries. And that's an exempt asset. Why?
No cash.
No cash value. Not worth anything, so you're dead. Okay, if you have a whole life policy, the whole life policies are an asset, and the asset is the amount of its cash surrender value. And it has to be computed into that $14,400. Income. If you're in an institution, the institutional Medicaid level for a nursing home, you're allowed $50 a month as a personal needs allowance. Frankly, if you're in a nursing home, you really probably don't have a whole lot of other needs, realistically. But that's what you're allowed, and if you need, if a hairdresser costs more or whatever, there's usually somebody around to help pick up that tab for you. The tough area is in the community Medicaid area, because if you're in home, you're only allowed 800, and we'll work with singles at the moment. Singles are allowed $820 a month. Okay. Anybody know of anybody who can manage to get by on $820 a month in Westchester County, whether it be rent or whatever, and pay their taxes, their water bill, their cable bill, or anything else?
My dog.
Okay. Pardon?
My dog.
Your dog, right? Okay. So, what the hell do you do? Pardon me. What the heck do you do? What do you do if you have income in excess of $820 a month? Seems like there's always something, right? Way to get around it. There's something called a pooled trust. There's several of them out there. The gist of what happens is you take your excess income over the 820. It gets assigned to the pooled trust. Then the pooled trust can turn around and pay your bills for you. So let's say you have $5,000 of income a month. You can keep the 820. The balance of it goes to the pooled trust. The pooled trust then turns around and pays your utility bills and your taxes and this, that, and the other things, so you can get Medicaid. Don't even ask. I think, I hate to say this, but there are all these lawyers, right, in Albany and in Washington, and, so the only thing that gets done by all this is their legal fees.
Where does your Social Security retirement come in as far as this income? You're getting Social Security.
Your social, so,
$2,000 a
right,
month. What is,
that's income.
that's part of your income.
Yeah, any kind of income is income. There are some very rare exceptions,
So that goes to the nursing home.
which off the top of my head, I mean, if you have Nazi war crime benefits that you're getting, and I mean, there are a variety of different crazy minimal things that are not included as income, but for 99% of my clients, any income they get, pension, you know, and for the retirement, what will be treated as income, let's say your RMD for the year is $12,000, to make math easy, then they will allocate $1,000 a month of it as, regardless of when you take it, as your monthly income. So, let's say you have your RMD on a monthly basis comes out to $1,000. Your Social Security is $1,800. You've got $2,800 worth of income. You can keep the $820, and the rest of it better go into the pooled trust, or it's going to have to be spent down on your care. Yes.
And who's the trustee for the pool trust?
There are organizations out there, it's professional pool trusts. I mean, they're legit. I mean, they're absolutely legit, and they do what they're supposed to do, and it works. They take a small fee for doing it. Any money that's left in the pool trust at the end either goes to the trust itself or back to Medicaid. But by and large, there's not much left in the trust because you're only putting in as much as comes in monthly, and it's usually going out at the same rate. So that part of it's not a big deal.
Okay, what about spouses?
Okay.
A single is $820?
Everybody, it goes up from $820 to $1129 if you're a spouse. Insane. You don't even get double.
You can afford 2 dogs.
You don't even get double.
I
Yes, ma'am.
just want to clarify, the
Yeah.
403B and 401K,
They're all
Social
retirement accounts.
Security,
Right.
it all goes into your Medicaid, it all
It all,
goes to the nursing home.
well, we were talking home care at the moment, yes,
Oh.
but it also goes to the nursing home.
Yeah.
It's what's called the NAMI,
Yeah.
the net available monthly income. To go back to the nursing home, I can't remember where in this presentation I'll get to it. But the Social Security, using the same example we were using before of the 2,800, okay, you're allowed to keep 50. If you're in a nursing home, the difference between the 50 and your actual income is going to go to the nursing home before Medicaid comes in to pick up the difference of what the nursing home is entitled to receive. Okay, does that make, you got it?
Oh, I see, so before you're in a nursing home, Medicaid will take it anyway,
No, not before.
Okay.
If you're at home,
if you're at home.
you keep the 820 and you use the pooled trust
Oh.
to pay your expenses
When is that set up, that pool trust?
when you apply for home care Medicaid. It's all done at the same time.
Oh,
So it's all done simultaneously.
So back to the other point, if you're in a nursing home, you're saying that you keep 50, the rest of your income goes to the nursing home. If that's not enough, they go to Medicaid to pay for
Correct.
it.
I mean, if you happen to have an income that's high enough that it covers the cost of the private pay of the nursing home, which runs anywhere between $10,000 and $14,000 a month now, if you happen to have that kind of income, you're not a Medicaid candidate. And I might add, in my own opinion, nor should you.
And what about the spouse at home?
Okay, the spouse at home, if you have someone in a nursing home, that's where we're going next. So married couples do have some advantages. They also have some disadvantages. The biggest disadvantage for a married couple is that both spouses' assets are counted towards the $14,400 because under the law you have a legal obligation to take care of your spouse. So you are responsible for the health costs of your spouse. That's sort of the bad news. So that even if your assets have been split up so that they're 50-50 for estate tax purposes or whatever the heck else reason you've done it, all those assets, any joint accounts, even with your kids, any joint account, any account you have access to, because it's a joint account or otherwise, or a 529, they're all considered the assets that are available. But they also, in their wisdom, and this is what I think they should do for community Medicaid, but they haven't, it would take away the problem of the pooled trust, and it's a lot easier to, to deal with. The community spouse, which is the well spouse in the community, is entitled to non-exempt resources of a minimum of $74,820 and a maximum of $115,920. Okay?
A year.
No, those are your resources. That's not income, that's resources. That's what you can have of non-exempt resources. Since the house is an exempt resource, okay, and it's usually the most, the biggest asset you have, that's not part of the problem. But even then, most of my clients, and the way you figure it out is you add up the assets, you divide by 2, and if there's a, it's obviously, I think because this is bare bones, I didn't put this stuff in here. It's actually in my handout, but you can figure out the math of it. If you take it up and you divide by 2, the minimum you're going to get is a 74,820. If it's above 130 something or 132 something, the best you're going to get is 115,920. There are appeals that you can do. The standard for getting an increased community spouse resource allowance, which is what this is called, the CSRA, is incredibly difficult to meet. They are, however, entitled to $2,898 per month in income. That was not so terrible. I mean, that's a pretty decent amount of money. And if the spouse herself doesn't have that kind of income, they can take it from the institutionalized spouse's Social Security or their pension. Okay? So that's the one instance where that income that's going to the institutionalized spouse can be sucked out a little bit, up to $28.98 per month. Just want to see whether again, I can do easily 2 hours on Medicaid. I did 3 hours a couple of weeks ago. So what happens if you have excess resources and excess income? Well, if you have excess resource, first of all, if you have the excess resources, the spouse has to file something called a spousal refusal. Okay? Sounds awful. I refuse to support my spouse. Let him suffer. It's a formality. I mean, in order to qualify, you have to file a spousal refusal. Okay? And then Medicaid is obligated to determine your institutional spouse's eligibility based on his assets and his assets alone. Okay? But what's the consequence? Your spouse also has to sign a assignment of rights to the state. So the state can come after the community spouse who's at home. Okay? Eventually. If the income is over, same thing. Spousal refusal, the state can come after the excess income. Why would we do this? Well, there are a couple of reasons. First of all, even though they're getting tougher about going after people, if your spouse is on Medicaid, Medicaid is probably paying, if it's let's say it's a $12,000 a month private pay nursing home, Medicaid's probably paying anywhere from $6,500 to $7,500 a month. Okay? What you're going to be obligated to repay Medicaid is what they pay. So, for argument's sake, you're saving anywhere from, a third to a half of what it would otherwise you'd actually be paying out if you hadn't qualified your spouse for Medicaid. That's on the resource, that's the resource side. If they sue you, and they're not going to, look, there have been cutbacks all over the place. They don't have time to go chasing after everybody, and they don't. And when they do, they don't want to go to court about it. They're happy to, they'll negotiate with you. So there are advantages. On the income side, they only look for 25% of the excess income. So let's say your income is $3,000, $4,000 above the minimum monthly maintenance needs allowance, which is what this is. MMNA, the MIMNA. Everything has a name. They'll only look for a $1,000 contribution from that $4,000 excess income. Okay, so in many cases you convert resources to income producing. Why? Because it depends how you want to play it. I mean, your elder law attorney will sit down with you and go through all the different options on this. But even notwithstanding the fact that they can come after you, and notwithstanding this, that, and the other thing, the reality is that you're still better off getting your spouse on Medicaid than not having him on Medicaid, or her on Medicaid.
Yes.
What time is it?
10 after 1.
My watch stopped. I had 10 after 12, and I said, I can't have only been talking for 30 minutes. I'm sorry. I guess it needs a new battery. 40 minutes? All right.
So if you could...
Does anybody want to bear with me for just a second? I'm going to do this one thing on the look back. Or I'll talk to somebody outside. I don't care.
I just wanted to ask a higher level question. If the Medicaid system was basically set up so that less affluent people could get by,
right?
And you talk about Medicaid planning.
Mm-hmm.
It seems to me we're talking about how can we game this system so that we can qualify Uncle Harry's money so we can get some of it.
Okay.
And what are the ethics?
There's very much a philosophical issue here, obviously. I mean, the first answer I have to the question in terms of what I do for a living is, you take advantage of the tax law loopholes. Nobody's not going to take the deductions they can, and they do. And in my instance, my job is to try and qualify people for Medicaid if I can. Every lawyer, particularly this one, has a certain, there are cases I will not take. I believe philosophically, my own personal opinion, that the government has a responsibility, should have a responsibility to be able, after X number of years of paying in, to take care of their elders. Okay, and there shouldn't be a difference between if you die of a heart attack and you end up with Alzheimer's. Okay, that just in one case it drains all the money you've earned all your life and your kids get nothing, and in the other case, you drop dead and the kids get an inheritance. But the question of what numbers you use, at what point in time do you decide that how much should somebody be able to pass on to their heirs, given the philosophical issue? And that's the only way I can answer your question. Will you bear with me? I just want to get through the look back, or I can answer it outside. That's it. The last slide. Last slide.
Agreed? Because I think people want to know what that look back is.
Okay, so the look back period is 5 years. I really have basically explained it already. The look back is 5 years. The penalty is done county by county. It's based on what they consider the average cost of a nursing home. In Westchester, it's $10,737. For every $10,737 you give away, there's a 1-month penalty. In Nassau, it's $12,034. It just varies from county to county. In New York City, it's another number. So if you've given anything away during that period of time, you're going to have a penalty imposed, and the elder law attorney that you visit with will explain how to deal with it.
But does that mean you delay going to the nursing home, or that you've got to pay the full price for that period?
You're going to pay a full price
Yeah.
for that period. I sort of run out of time because I've been led to believe you guys had a little more Medicaid background than you do, but look, I can be in another room, I can be anywhere. I'm happy to stick around for a while and answer any specific questions or whatever, and of course, if anybody wants to contact me can. With that, I apologize for running over.
Don't
Sorry.
apologize at all. Those great.
Anybody know somebody who supplies batteries for watches?
There are handouts, and Jeff has his card there if you need it. Thank you so much.
Thank you.